Hello and welcome to a fresh episode of Legal Wrangle. In today's episode, we'll present before you the latest judgments pronounced by various benches of the High Courts in the field of GST. Let's proceed to our first case. The petitioner had filed an application before the Authority for Advanced Ruling seeking to know if books such as Sulekh Sarita Part A, Sulekh Sarita Part B and Sulekh Sarita Part 1 to 5 would classify as printed books falling under HSN 4901 or as children's drawing books under HSN 4903 or as exercise books under HSN 4820. It may be noted that while classification under HSN 4901 and 4903 would result in exemption from duty, classification under HSN 4820 would attract 6% tax.
The AAR held that the product in question was correctly classifiable under HSN 4820 and not under HSN 4901 or 4903. It was also held that the books are not covered under entry number 119 or 121 of notification number 02 of 2017 central tax rate. Against such findings of the AAR, the applicant filed writ petition before the High Court.
The High Court observed that it was relevant to determine the purpose that the book would serve. It had to be determined whether the books would merely help improve a child's handwriting by enabling the child to copy some written text, or did the books contain questions for the child to answer, which would then be examined by a teacher to evaluate the child's ability and understanding.
The High Court observed that the practice books printed and sold by the petitioner tested the child's knowledge and served to evaluating the child's understanding. Hence, the books did not classify as exercise books as understood by the trade. The petitioner also produced samples of exercise books as understood in trade parlance. These were simply bound volumes of blank pages facilitating writing. Hence, the High Court concluded that the books in question were classifiable under HSN 4901 and were exempted from duty. Thus, the AAR's order was set aside. Let's proceed to the next case.
The premises of the SST company were subjected to search proceedings during the relevant period. Several documents and records were seized and statements of various persons, including the company's managing director, were recorded. During investigation, when the assessee sought access to seized records and statements taken, it received no response from the revenue despite exchange of much correspondence. Hence, a writ petition was filed seeking that the revenue be directed to provide the material sought for.
The High Court noted that while the revenue's interests were paramount and had to be protected, the revenue's actions drew their authority from a holistic interpretation of legal provisions. Noting that the GST enactment subsumes various enactments including the Central Excise Act, the Finance Act providing for the levy of service tax and State Value Added Tax Acts, the interpretation given to the provisions of the aforesaid statutes would equally govern the working of the present statute as well. The High Court adverted to the Delhi High Court decision in Make My Trip India Private Limited, and which has been confirmed by the Supreme Court. In this case, the High Court held that it is mandatory to follow the procedures contained in Section 73A Clause 3 and 4 of the Finance Act before going ahead with the arrest of a person under Section 90 and 91. It then observed that any excesses in the exercise of such powers would vitiate the assessment proceedings. It was also noted that Section 132 of the CGST Act imposed punishment on an assessee who commits an offence. Thus, the term commits clarified that the commission of the offence must precede the punishment meted out.
The revenue's allegation was that the assessee violated the provisions under Section 16 Clause 2 of the CGST Act by availing excess ITC without actual movement of goods and through bogus transactions. Hence, the court observed that determination of excess credit as per the procedure under Section 73 and 74 of the CGST Act was a prerequisite for recovery of such credit alleged to be availed fraudulently. Hence, the court rejected the revenue's argument that punishment could be imposed prior to assessment, noting that the same was tantamount to placing the cart before the horse.
The court also observed that the assessee did not classify as an offender, leave alone a habitual one, which would justify the preemptive action of imposing penalty. The High Court found the actions of the revenue to be attempts to intimidate the assessee with the possibility of punishment under Section 132 of the Act, noting that such conduct was contrary to the scheme of the Act. It was thus held that the power to punish was to be invoked only if it is established that an assessee committed an offence and that such determination necessarily had to follow the process of assessment. With such observations, the writ petition was allowed. Let's move to the next case.
The revenue attached the bank accounts of the petitioner company during the relevant period, considering that the liability of about 3.03 crores was liable to arise on account of penalty imposed under the Gujarat VAT Act 2003, in addition to penalty of Rs 2.5 crores under the GST Act. The petitioner then approached the High Court seeking relief.
The court observed from a perusal of Section 45 of the Gujarat VAT Act that the Commissioner was empowered to provisionally attach property belonging to a dealer so as to protect the revenue's interests. Hence, the issue arose as to whether the scope of government revenue would also include penalty, which a dealer may or may not be liable to pay on a later date. Observing that the matter needed further consideration, the court directed that notice be issued to the parties. As interim relief, the revenue was directed to lift the attachment over the bank accounts. Let's proceed to the next case. The petitioner company runs a chain of fast food restaurants under the brand name of Domino's. It approached the High Court challenging an order passed by the National Anti-Profiteering Authority, which in its order dated January 31, 2019, had found the petitioner to have profiteered from the supply of food items by charging a price higher than what was chargeable. It was also held guilty of issuing incorrect invoices.
Apart from challenging such order, the petitioner also contested the vias of Section 171 of the CGST Act as well as of Rules 126, 127 and 133 on grounds of being violative of Articles 14 and 19 of the Constitution. The composition of the National Anti-Profiteering Authority was challenged too, with the lack of a judicial member being pointed out. The petitioner also claimed about there being no authority to review the orders of the NAPA. It was also claimed that while the petitioner dealt with 393 products and that while the NAPA acknowledged its compliance with prices in respect of most of the products, the NAPA had selectively drawn adverse conclusions by considering the prices charged for a few products.
The High Court also noted that the petitioner had made out a prima facie case on account of which the balance of convenience stood in its favour. The petitioner was directed to deposit a sum of Rs 20 crores with the Consumer Welfare Fund out of the total duty demand of about Rs 41.42 crores in compliance with the NAPA order. It then directed that the matter be listed for hearing on August 22nd. The petition was disposed of with these observations.
The allegation against the respondent herein is that it profited on the supply of glass kit hood curved black electric chimney on grounds that it did not pass on the benefit of reduction in GST from 28% to 18% with effect from 15th November 2017.
Later, the National Anti-Profiteering Authority held that the contention that the effective tax rate during the VAT period was around 18% and the GST rate with effect from 15 November 2017 was also 18%. Therefore, there was no need for revision in price when the tax rate had been decreased from 28% to 18%, which was untenable.
It also held that the argument that the price of electric chimney was not increased at the time of introduction of GST when tax rate was fixed at 28%. Hence, question of reducing price when GST rate was brought down to 18% was legally unsustainable.
The petitioner company is a leading manufacturer of medicines and cosmetics. It filed a writ petition challenging an order passed by the National Anti-Profiteering Authority, which had held that the petitioner to be guilty of profiteering on supply of Melaglow rich cream. The petitioner had been charged with issuing incorrect invoices, which was an offence under Section 122 of the CGST Act. The authority also proposed to impose penalty under Rule 133 of the CGST rules.
The petitioner thus challenged the bias of Section 171 of the CGST Act and Chapter 15 of the CGST rules, and in particular Rule 126, 127 and 133. The High Court noted that the petitioner had undertaken to pay the amount allegedly profiteered. It also noted that similar petitions were pending before it, challenging the validity of these provisions while also contesting the NAPA's orders. Hence, it granted stay on the proceedings arising from NAPA order in the petitioner's case and directed that the matter be listed for hearing on August 22, 2019. This brings us to the end of today's episode of Legal Wrangle. Please stay tuned to TIOLtube.com for our upcoming videos. Please also feel free to share your views with us at editor@TIOL.in. Thank you for watching. Have a nice day.